But new tonight, our investigative team learning the charges in the Rust case are now being questioned.
I'm hoping they go back and they look at the law and they voluntarily do what they should, which is dismiss those firearm enhancements. If they do not.
That was Jason Bowles, attorney for Rust Armor, Hannah Gutierrez-Reed.
She is facing up to 6.5 years in jail. Now, this afternoon, Bowles talked exclusively with Target 7's John Cardinelli about how the charges filed should be thrown out.
That's exactly right, Shelley and Doug. Bowles is arguing the firearm enhancement added to the involuntary manslaughter charges for Gutierrez-Reed are not valid. He tells me he's taking action.
Jason Bowles, attorney for Rust Armor, Hannah Gutierrez-Reed, says the Santa Fe County District Attorney's Office has made a mistake.
Is the firearm enhancement charge that your client is facing accurate?
It is not accurate. It is the 2022 version, which is not applicable to a crime that is alleged to have occurred in 2021.
KOAT legal expert John Day says Bowles has an argument.
The law that was in place at the time of the shooting is the law that's essentially going to control, because you can't have what's called ex post facto laws that adjust the laws to make things after the fact more serious or even less serious.
Now, what does the 2021 version say?
The prior law, you'd had to have with the brandishing, you had to have the intent to intimidate or to assault somebody, in essence. And I don't think they can prove that on anybody.
So based on the law that was in place at the time, your client would have had to have had some sort of intent.
That's absolutely correct, and she did not have that intent. She could not have had that intent. She didn't have the weapon in her possession, so she did not have the intent. And she did not violate that firearm enhancement that was on the books at the time.
Did the DA's office make a mistake?
They made a huge mistake. I mean, it's very clear in the law you cannot charge a statute that's passed after conduct occurs. I mean, that's been going back to our Constitution, literally.
But Day says there may have been no mistake made.
You know, if that's how the DA charged it, you have to assume that she has a plan. At the end of the day, it's one of the elements she's going to have to prove if she wants that firearm enhancement.
Do you believe the DA has any way to prove that brandishing a weapon with intent to injure was at play in the case?
I don't believe they can prove that. They can't prove it on Hannah Gutierrez-Reed. She did not even have the weapon at the time.
Will you file a motion to have the firearm enhancement thrown out?
We are going to file motions to have the firearm enhancement thrown out. Clearly unconstitutionally applied in this case by the DA. It's kind of unbelievable they charged it.
And Bowles says his motion should be officially filed tomorrow. If the firearm enhancement is thrown out, Gutierrez-Reed faces up to 18 months if convicted. For Target 7, I'm John Cardinelli.
The DA's office sent us a statement writing the district attorney and special prosecutor are actively reviewing all applicable laws to ensure they have the strongest case to secure justice for Halyna Hutchins.
A new lawsuit.